Chapter IV, Status of Attacking Creditors. SS 73, Rights of Creditors at Large. A creditor at large, commonly called a simple creditor, cannot assail as fraudulent against creditors, an assignment or transfer of property made by his debtor, until the creditor has first established his debt by the judgment of a court of competent jurisdiction, and has either acquired a lien upon specific property, or is in a situation to perfect a lien thereon and subject it to the payment of his judgment, upon the removal of the obstacle presented by the fraudulent assignment or transfer. This principle is elementary, a rule of procedure which allowed any prowling creditor, before his claim was definitely established by judgment, and without reference to the character of his demand, to file a bill to discover assets, or to impeach transfers, or interfere with the business affairs of the alleged debtor, it is asserted would manifestly be susceptible of the grossest abuse. A more powerful weapon of oppression could not be placed at the disposal of unscrupulous litigants. A creditor at large, having no lien or trust, is not favored in the class of litigation under consideration, and, generally speaking, has absolutely no status in court for the purpose of filing a creditor's bill. The possibility of a judgment will not suffice. The rule is peremptory. A court of equity never interposes, says Ruffin, C.J., in behalf of a mere legal demand, until the creditor has tried the legal remedies and found them ineffectual. It is not intended by this rule to exclude simple contract creditors from the operation of the statutes against fraudulent conveyances, they being, except perhaps as regards statutory liens, as much protected as creditors by judgment. But until such creditors have obtained a judgment and acquired a lien or a right to a lien upon the debtor's property, they are not in a position to assert their rights by a creditor's action. It is observed by Brown, J., in Paulson v. Van Steenberg, that a court of equity is not the forum for litigating disputed claims, and, as a general rule, will not entertain an action or afford relief to a creditor until he has established his debt in a court of law. Courts of equity are not tribunals for the collection of ordinary demands. The debt, said Field, J., must be established by some judicial proceeding, and it must generally be shown that legal means for its collection have been exhausted. When a conveyance is said to be void or voidable against creditors, the reference is to such parties when they are clothed with judgments and executions, or such other titles as the law has provided for the collection of debts. Judge Bronson, in Noble v. Holmes, after declaring that a fraudulent sale could not, under the provisions of the revised statutes of New York, be impeached by a creditor at large, added it must be a creditor having a judgment and execution, or some other process which authorized the seizure of the goods. It may be urged that, where a debtor is manifestly guilty of fraudulent conduct with reference to his property, the prerequisites of a judgment and execution will prove serious impediments to an ordinary contract creditor who desires to take immediate action to reach the property which the debtor is dissipating or concealing. But the answer to this proposition has been that the remedy of a creditor so situated is not by creditor's bill. He must seek provisional relief by arrest or attachment, or both, in a suit founded upon his contract claim. A creditor in this position is not, as we have seen, entitled to interfere by injunction before judgment with any contemplated alienation of property by the debtor, even after instituting suit by attachment. So stockholders cannot sue in the right of a corporation without first trying to set the body itself in motion, and a creditor or member who desires to sue in place of a receiver must set forth that the receiver declines to proceed. To recapitulate, then, the judgment and execution are necessary to a creditor before proceeding in equity. First, to adjudicate and definitely establish the legal demand, and save the debtor harmless from interference at the instigation of unconscionable claimants. Second, to exhaust the legal remedy. The maxim, lex neminem cogit ad vana sua in utilia perigenda, has struggled for application in cases where it is manifest the judgment at law will be ineffectual or worthless, but though the sympathy of the profession seems to favor a relaxation of the rule requiring a judgment and execution before a proceeding by creditor's bill will lie, yet, generally speaking, the absence of a judgment proves fatal to such a bill. A guarded statutory reform might be suggested with a view to enlarge the facilities of creditors to reach equitable assets. Complainants holding liquidated demands, founded upon written instruments or express contracts, might be given a right to proceed to attack transfers against debtors who have made general assignments, or against whom unsatisfied judgments rest, or who have suspended business solely from lack of funds or have become notoriously insolvent. SS 74. Judgment conclusive as to indebtedness. In cases where fraud is established, the creditor does not claim through the debtor, but adversely to him, and by a paramount title, which overreaches and annuls the fraudulent conveyance or judgment by which the debtor himself would be estopped. It follows from the principles suggested that a judgment obtained without fraud or collusion, and which concludes the debtor, whether rendered upon default, by confession or after contestation, is, upon all questions affecting the title to his property, conclusive evidence against his creditors, to establish, first, the relation of creditor and debtor between the parties to the record, and secondly, the amount of the indebtedness. This principle is assumed in the New York statute in relation to creditors' bills, and is so decided in Rogers v. Rogers. The execution issued upon the judgment shows that the remedy afforded at law has been pursued, and of course is the highest evidence of the fact. The return shows whether the remedy has proved effectual or not, and, because of the embarrassments which would attend any other rule, the return is generally held conclusive. The court will not ordinarily entertain inquiries as to the diligence of the officer in endeavoring to find property upon which to levy. SS 75. Creditor must have lien before filing bill. We must then accept the general rule that a court of equity will not interfere to enforce the payment of debts until the creditor has exhausted all the remedies known to the law to obtain satisfaction of the judgment. It is usually essential in order to give the court jurisdiction and to reach equitable assets, that an execution should have been issued upon the judgment and returned unsatisfied, or, if an action is brought in aid of an execution at law, that it be outstanding. The commencement of the action will then give the creditor a specific lien. The rule that the legal remedy must be exhausted by the judgment creditor before relief can be solicited to reach property not subject to the lien of the judgment is an ancient one. It existed in England and was recognized by the Court of Chancery in New York before the provisions made by the revised statutes of that state, which require that an execution be issued and returned unsatisfied in whole or in part, before a bill can be filed to compel a discovery of property and to prevent a transfer of it. This statute, says Chancellor Walworth in Child v. Brace, is only declaratory of a principle which had before been adopted in this court. Hence, the creditors of an insolvent partnership must acquire a legal or an equitable lien upon the property of the firm to authorize them to invoke the equitable powers of the court and its administration. Nor does the fact that the debtor is an insolvent corporation and has alienated its property in contravention of the statute authorize a resort to equity until the remedy at law has been exhausted by judgment and execution returned unsatisfied. SS 76. Judgments sufficient. An ordinary money judgment rendered in the state in which the debtor resides and the concealed property is located is manifestly a proper foundation for a creditor's suit. A bill of this character may also be filed to aid in the collection of money decreed in Chancery. I have no doubt, however, said Chancellor Walworth, that a creditor, by a decree in Chancery, upon the return of his execution unsatisfied, is entitled to the same relief against the equitable rights and property of his debtor, as a creditor by a judgment at law. A justice's judgment will suffice, especially if docketed in a court of record, and a judgment by confession, even though defective in form and particularity of statement, authorizes the creditor to impeach a fraudulent transfer. So does a demand classified and allowed by a probate court under a judgment against joint debtors only part of whom were served with process. A creditor's action may be prosecuted to reach joint property, but not the separate property of those not served with process in the original suit. Supplementary proceedings may be taken on a judgment so recovered to reach joint property. SS 77. Judgments insufficient. It seems clear in New York at least that a creditor's action cannot be founded upon a judgment recovered in a justice's court where the execution had only been issued to and returned by the justice. It should be docketed in and made a judgment of a court of record. It then becomes as much entitled to the aid of a court of equity as though originally recovered in a court of record. Again, a judgment in an attachment suit where the defendant has not been brought into court so as to make it a personal judgment is not evidence of the debt in another suit founded upon that record. and a creditor's bill cannot be brought upon a judgment barred by the statute of limitations, and an action based upon a judgment rendered against executors in their representative capacity is not maintainable to set aside as fraudulent as against creditors, a conveyance of real estate made by a decedent. This latter case seems to result in a denial of justice. The court said that if the facts recited in the complaint were true, it was the duty of the executors to reclaim the real estate. Earl J. observed the fact that the fraudulent grantee is one of the executors furnishes no insurmountable obstacle. If she should refuse to restore the lands to the estate, she could be removed from her office of executrix, and then the remaining two executors could, under the Act of 1858, disaffirm the conveyances of the real estate and bring an action to set them aside, or the two executors could commence the action making the executrix a defendant, and in such an action obtain for the estate the relief demanded. If the two defendants refuse to commence the action upon the application of the creditors, or some of them, they could be compelled to commence it by an order of the surrogate. Parties experienced in suits instituted to annul fraudulent conveyances will readily appreciate the perfunctory manner in which these executors would be likely to prosecute their associate. SS 78. Foreign judgments. Usually a foreign judgment will not suffice as the foundation of a creditor's bill. In Buchanan v. Marsh, which was an action in the courts of the state of Iowa on a judgment rendered in Canada, an injunction was asked restraining the defendants from alienating or encumbering their real estate until the rights of the parties should be determined at law. Wright, C.J., said plaintiffs are not judgment creditors. For the purpose of the present inquiry, their action is like any ordinary one upon a note, account, or any simple contract, or evidence of indebtedness. They have a foreign judgment, but until it becomes a judgment in our courts, they are no more than creditors at large, and until they obtain the recognition of their claim by the adjudication of our state tribunals, they have no other or different rights as to the property of their debtor than if their demand was endorsed by a less solemn or conclusive proceeding or instrument. For, however effectual such judgment may be, or whatever the faith and credit to which it may be entitled, it is very certain that it cannot be enforced here until its validity is recognized and passed upon by the judgment of our courts. This being so upon common law principles, we know of no principle upon which plaintiffs were entitled to this injunction. The rule is, as far as we know, without exception, that the creditor must have completed his title at law, by judgment before he can question the disposition of the debtor's property. The weight of authority sustains this view. On the other hand, upon a judgment recovered in Pennsylvania, an attachment was issued in New Jersey, and the lien thereby created was held to be sufficient to enable the creditor to attack a fraudulent transfer. Again, in Wilkinson v. Yale, a creditor's bill was maintained in the United States Circuit Court, founded upon a judgment of a court of the state in which the federal court was sitting. Still, the general rule is that a foreign judgment ranks as a simple contract debt. It does not have the force and operation of a domestic judgment except for the purposes of evidence, beyond the jurisdiction in which it is obtained. SS 79. Creditors of a decedent. The question of the necessity of a judgment as the foundation of a creditor's proceedings, in cases where the debtor is dead, has created much dissension in the courts. S. V. Wilcox, an important case in the New York Court of Appeals, is to the effect that a creditor without judgment and execution return cannot maintain an action to enforce the resulting trust under the statutes of uses and trusts in lands purchased and paid for by the debtor and deeded to another, although the debtor died insolvent. It was held that these facts did not dispense with the observance of the general rule that a debt must be fixed and ascertained by judgment, and the legal remedies exhausted. It is contended that the reason of the rule that a creditor's debt must be ascertained by judgment before proceeding in equity does not necessarily fail by the death of the debtor before judgment recovered upon the debt. The creditor may prosecute the claim to judgment against the personal representatives of the debtor, and, although it will not be conclusive against his heirs or his grantees by title acquired before his death, it would conclude the creditor as to the amount of his claim. But we cannot discover that the judgment against the personal representatives would be of much worth to the creditor. This case certainly extends the requirement to an extreme limit, and the correctness of this rule is not uniformly conceded, and in a number of states the principle is asserted that no proof of the recovery of judgment is necessary where the debtor is dead, as the judgment would be useless and unmeaning in Hagen v. Walker. Mr. Justice Curtis, a very learned and able jurist, held that a simple creditor might maintain a suit to remove a covenant's conveyance and reach assets against the administrator in the fraudulent alienee of a deceased debtor. The court was of opinion that such a case was not to be treated as an application by a judgment creditor for the exercise of the ancillary jurisdiction of the court to aid him in executing legal process, but came under the head of original jurisdiction and equity. The authorities upon this subject cannot be reconciled. The best reasoning would seem to be what the case is holding, that no judgment need be recovered against the decedent's estate, and in favor of allowing the creditor both to establish his claim and to discover assets to be applied toward its payment in the same action. The practice of allowing executors and administrators to prosecute actions to annul fraudulent transfers in the interest and right of creditors will be noticed presently, where the personal representatives sue the necessity for judgment and execution returned unsatisfied is superseded. SS 80. Rule as to judgments in equitable actions. The remedy, it seems, must also be exhausted where the judgment proceeded upon was rendered in an equity suit. Thus in Geary v. Geary, which was an action brought to set aside conveyances of real estate alleged to have been made by the defendant, through other persons, to his wife, in fraud of creditors, there was no proof of the docketing of a judgment and of execution returned unsatisfied, and the point was taken that the ordinary remedy usually available to creditors had not been exhausted. The creditor sought to obviate this objection by urging that the rule did not apply where the judgment sought to be collected was rendered in an equitable action. It appeared that the foundation of the complainant's claim was a judgment rendered upon a partnership accounting, but the judgment had not been docketed, nor had any execution been issued upon it. Earl J. said, "I can perceive no reason for a distinction. A suit in equity to enforce satisfaction of a judgment should not be allowed so long as there is a more simple and obvious remedy. The statute law gives a remedy by execution, and that remedy, upon every reason of public policy and convenience, should be exhausted before a new suit should be allowed to be maintained." Then Johnson J. observed in Crippen v. Hudson that the Court of Chancery required executions to be returned unsatisfied when issued on its own decrees before it would entertain creditors' bills founded upon them. There is, however, a rule running through some of the cases to the effect that where the claim asserted is purely equitable, and such as a court of equity will take cognizance of in the first instance, equity will at the same time go to the extent of inquiring into the matter of obstructions which have been placed in the way of enforcing the demand. For instance, where a surety has paid money for a principal, Chancery has jurisdiction of the suit for its recovery, and the complainant may add a prayer seeking to annul a fraudulent conveyance that stands in the way of a settlement or is calculated to defeat or embarrass the remedial action of the court. SS 81. Specific lien by attachment. In cases where the sheriff takes property upon attachment which is subject to seizure and sale, but which has been fraudulently transferred, it seems that the plaintiff, after the service of the attachment, is not a mere creditor at large, but, according to some of the authorities, one having a specific lien upon the goods attached, and that the sheriff has a like lien, and the right to show, as a defense to an action for taking the property, that the title of the party claiming it is fraudulent as against the attaching creditor. Hence it was held, in an action brought by a general assignee for the benefit of creditors, to recover goods seized by a sheriff on a warrant of attachment issued against the assignor, that it was permissible for the sheriff to show that the assignment was fraudulent and void as against the attaching creditors. There is some confusion, however, in the authorities on the question of the right of an attaching creditor to attack fraudulent transfers. The Supreme Court of Nebraska and the courts of some other states deny such right in a variety of instances. The Nebraska case is rested upon the authority of Brooks v. Stone, which proceeds on the theory that the creditor's remedy at law is not exhausted, his claim is not established, and perhaps he will never get a judgment. So garnishment process does not create a sufficient lien to uphold a creditor's bill. In New York, a state in which the authorities relating to the different phases of our subject are burdened with subtle distinctions, it is said that an attaching creditor could not maintain an independent action in the nature of a creditor's bill to set aside a fraudulent transfer of a chosen action. This case rests upon the theory that the attachment, owing to the nature of the property, created no lien, but where a lien is in fact acquired, the rule, as already stated, seems to be different, especially when the attaching creditor is a defendant at the suit of the fraudulent alienee, and relief will be in some instances extended both in that state and in sister states for the vindication of the lien. In Boe v. Arnold, the courts of New York held that the plaintiffs, in an action instituted by attachment, could not join with the sheriff in a suit against an assignee claiming the property under an assignment which it was sought to set aside in the action as fraudulent. It was conceded that such parties might join in that state in actions to collect debts, effects, or choses in action attached by the sheriff, but the court observed that this was not such a case. The counsel sought, upon the authority of Bates v. Plonsky, to maintain the action as being instituted for the protection, preservation, and enforcement of the lien obtained by the supposed levy of the attachment, but the court said that the precedent cited was a suit of a different nature, and was prosecuted merely to enjoin the distribution of a fund until the rights of the conflicting claimants could be established. It is observed in the course of the opinion that a creditor could only file a bill to annul a fraudulent transfer after return of execution unsatisfied, or in aid of the execution after the recovery of a judgment. The judgment in this case is undoubtedly correct, but in view of the other authorities cited, it can scarcely be considered as leaving the law of that state relative to the rights of an attaching creditor in a very clear or satisfactory condition. We deny that a mere attaching creditor can, under any correct theory of law, become an actor in a creditor's suit. Indeed, the underlying principles of the cases in which it is sought to make a lien acquired by the provisional remedy of attachment the practical equivalent of a lien procured by final judgment are subversive of the time-honored policy and rule of the courts that a creditor's bill must be founded upon a definite claim established by a judgment at law. If the innovations in modern procedure call for the abrogation of this old chancery practice, it should not be superseded by indirection, but deliberately and by some carefully formulated legislative substitute. The requirement is neither artificial nor technical. It is a necessary protection and safeguard to the debtor, manifestly where the property in controversy is of such character as not to be susceptible to an attachment lien. The attaching creditor cannot, either as plaintiff or defendant, avoid or attack any alienation or disposition that may have been made of it. He has no status and no lien. Where, however, an attachment lien has been actually acquired, and the officer or attaching creditor is made defendant in a suit by the fraudulent alienee, the efficacy of the lien may be vindicated by setting up the fraud by way of defense, because the plaintiff will be forced to recover upon the strength of his own title, and if it be shown that such title is affected with fraud as regards the defendant or attaching creditor, the plaintiff will fail to make out a good title. SS 82. Property of the debtor taken in name of third party. The rules of procedure in cases where property has been paid for by the debtor, but the title taken in the name of third parties, have already been noticed. The New York Court of Appeals in the Ocean National Bank v. Alcott said, ill-advisedly as we think, that it was difficult to perceive the reason for any distinction between the rights of creditors as to the property fraudulently transferred by the debtor personally, and property paid for by him and transferred by the vendor or grantor to a third person. Why, said Chief Justice Church, should creditors have different and superior rights to enforce their debts, in the latter case, to those enjoyed in the former? I can see no reason for any distinction, and I do not believe the statute has created any. But, in either case, the commencement of an equitable action is necessary to constitute a lien or charge, in any legal sense, upon the land. The harmony and analogies of the law are better preserved by requiring all available legal remedies to be resorted to, as a preliminary requisite to an action for the application of the trust property. In Ohio, it is said that the statute does not apply to cases where the title is taken in the name of a third party for the reason that the avoidance of the conveyance merely leaves the title in the grantor, which, of course, does not benefit the creditor. Such an interest, it is argued, must be reached by a creditor's bill. It cannot be sold on execution. This question arose in Spalding v. Fisher. It was held that property purchased with the funds of the debtor, though taken in the name of a third party, was the property of the debtor as regards his creditors. The court said its fraudulent transfer and concealment is equally established, whether the transfer is directly from the debtor or from another by his direction and procurement. the property transferred having been purchased with his funds. The object of the statute is to afford a remedy to the creditor against anyone to whom the property of his debtor, no matter in what it consisted or how situated, has been fraudulently transferred for the purpose and with the intent on the part of the debtor transferring and the individual receiving such transfer to conceal the same so as to secure it from the creditors and prevent its attachment or seizure on execution. SS 83. When judgment is unnecessary. It has been decided, though the question is a debatable one, that in special cases, if the execution cannot be issued in the state in which the land lies, it will suffice if issued in the state of the debtor's residence, and if the debtor's property is in the hands of a receiver appointed by the court, so that a levy cannot be made. Levy is excused, and where, by reason of special circumstances, the creditor has no remedy at law. It has been argued that the legal remedy cannot be exhausted before proceeding in equity. McCartney v. Bostwick seems to be in its general statements overruled by S.V. Wilcox. At least the courts have so held. A distinction is drawn in McCartney v. Bostwick between property fraudulently alienated by the debtor and property paid for by him and taken in the name of a third party. In the former instance, the proceeding is to remove impediments in the way of reaching the debtor's property. In the latter, it is to charge with a statutory lien the property of a third party, which the debtor never owned. In the one case, it is to exercise auxiliary jurisdiction in aid of legal process. In the other, to enforce a trust of which the courts of law have no jurisdiction. We have already shown that Chief Justice Church, in a later case, could see no reason for this distinction. In a controversy which arose in Georgia, it was decided that where a creditor of an insolvent estate was under injunction not to sue the executor, this constituted a good excuse for not obtaining judgment on his debt before proceeding by bill in equity to cancel a voluntary conveyance made by the testator in his lifetime. The court in this case seemed determined to favor the creditor, for it was held that if, during the pendency of the bill, a judgment or decree establishing the amount of the debt was obtained against the executor, it might be brought into the bill by way of amendment, and used as effectively as if the adjudication had preceded the filing of the bill, and had been originally alleged therein. Where the performance of a condition becomes impossible or illegal, performance is excused. So in some states creditors may proceed against an insolvent estate without the return of an execution. In case v. Beauregard, Mr. Justice Strong observed, but, after all, the judgment and fruitless execution are only evidence that his legal remedies have been exhausted or that he is without remedy at law. They are not the only possible means of proof. The necessity of resort to a court of equity may be made otherwise to appear. Accordingly, the rule, though general, is not without many exceptions. Neither law nor equity requires a meaningless form. Bona sed impossibilia non cogit lex. It has been decided that where it appears by the bill that the debtor is insolvent, and that the issuing of an execution would be of no practical utility, the issue of an execution is not a necessary prerequisite to equitable interference. This is certainly true where the creditor has a lien or a trust in his favor. Still, the observations of Mr. Justice Strong are not being accorded hearty approval even in the Supreme Court itself. In Russell v. Clark, Chief Justice Marshall, in discussing the general subject, said, if a claim is to be satisfied out of a fund, which is accessible only by the aid of a court of chancery, application may be made in the first instance to that court, which will not require that the claim should be first established in a court of law. Then, as we shall presently see, in cases where the statute gives a new remedy in favor of creditors at large, by giving to an assignee or trustee for their benefit a statutory right to property conveyed in fraud of creditors. This statutory right takes the place of the specific lien required by law as a condition of the right of individual creditors to contest the validity of the transfers. SS 84. Absconding in non-resident debtors. The fact that the debtor is a non-resident and has no property within the state is not proof that all the legal remedies have been exhausted. If he has fraudulently alienated real property within the state, his interest, whatever it may be, must be first reached by attachment, where, however, the debtor has absconded so that no personal judgment can be obtained against him, and there is no statutory proceeding by which his property can be reached. It has been held that a creditor's bill will lie in the first instance, and from the necessity of the case, it is considered as analogous to a proceeding to reach and subject the equities of a deceased debtor to the claims of creditors, or to satisfy a debt from a specific equitable fund, as to enforce a lien, in neither of which cases is a personal judgment required. A full review of the authorities upon this question may be found in Merchants National Bank v. Payne, an important and well-considered case. The court there maintained the right of a creditor, before the recovery of judgment, to file a bill to reach equitable assets where the absconding debtor had left no legal assets liable to attachment, and cite in support of their conclusion cases from Kentucky, Virginia, Indiana, South Carolina, and Missouri, and adopt the views of the Supreme Court of Missouri, already quoted. SS 85. Exceptional practice in Indiana and North Carolina. In Indiana, a novel practice as to joinder of claims prevails. Thus, a claim to cancel a conveyance of real property from a husband to his wife, as being fraudulent against creditors, may be united with a demand against the husband arising out of contract. Then, in an action against the husband and wife, instituted to obtain judgment against the husband for the price of goods sold, a fraudulent conveyance from the husband to the wife may be set aside so as to let in the lien of the judgment when recovered. It should be observed that this practice is wholly at variance with the prevalent rule that only judgment creditors can attack fraudulent transfers. Nevertheless, its technical correctness seems to be recognized in North Carolina. There the court declared it obvious that the rule exacting the recovery of a judgment at law before proceeding in equity grew out of the relations of the two courts under the former system, one acting as an aid to the other, and that it was essential to the harmony of their action and the exercise of their separate functions in the administration of the law. Chief Justice Smith, continuing, said, "It must of necessity cease to have any force when the powers of both, and the functions of each, are committed to a single tribunal, substituted in place of both. Why should a plaintiff be compelled to sue for and recover his debt, and then to bring a new action to enforce payment out of his debtor's property in the very court that ordered the judgment? Why should not full relief be had in one action, when the same court is to be called on to afford it in a second? The policy of the new practice, and one of its best features, is to furnish a complete and final remedy for an aggrieved party in a single court, and without needless delay or expense. This method of procedure constitutes a startling innovation. New York, the birthplace and stronghold of the reformed procedure, clings tenaciously to the old practice of requiring a judgment and execution before an appeal can be made to the equity side of the court. Not only has the rule been rigidly enforced in that state, but, as is shown elsewhere, it has been extended and strengthened. The rule has been relaxed in other states, but the cases which completely subvert or overturn it are comparatively few. The old method of procedure did not result, as the court supposed in Bank v. Harris, wholly from the relation of courts of law to courts of equity, nor is the necessity for its observance abrogated by the amalgamation of these jurisdictions. If the creditor is to be allowed to prove and recover judgment upon his simple demand, and cancel fraudulent conveyances, or reach equitable assets in the same action, it would seem to follow that the usual incidents of a creditor's suit would attach to the proceeding. The creditor in an action for assault and battery, libel, or slander might apply for an injunction against the debtor, or for a receiver of his property, or embarrass him by filing a lis pendens. The time-honored rule that the debtor's management and control of his property should not be interfered with by injunction or otherwise before judgment would be uprooted, and an unscrupulous creditor, having only the faintest shadow of a claim, could work out the debtor's financial destruction. The ancient practice must not be regarded as technical or artificial, but as a safeguard to the debtor dictated alike by reason and necessity. If the practice is to undergo a change, as seems likely in some states, then the joinder should be limited to cases of liquidated demands of creditors, certain in their character, and provisional relief should be withheld. The union is calculated to crowd into a single action a multitude of complicated issues concerning distinct transactions. As to the debt and the facts attending the alienation, a result always to be deprecated, and would necessitate the presence of the alleged fraudulent vendee in the action. SS 86. Return of execution unsatisfied. A cloud of cases may be cited to the general effect that, to reach personal property or equitable assets, By bill, a creditor must first secure the return of an execution unsatisfied unless it can be shown that the property is not susceptible to levy, and it is immaterial that the return of the execution was made at the request of the plaintiff, and within 60 days after its issuance. An embarrassing conflict of decisions, which must be noticed, arose between the Court of Appeals of New York in Thurber v. Blank and the Commission of Appeals of the same state in Mechanics Bank v. Dakin. The commission held that when a suit had been commenced by attachment and a judgment recovered, the plaintiff, after issuance of execution and before its return, could maintain an equitable action to set aside a fraudulent assignment of a bond and mortgage to the end that it might be applied toward the satisfaction of the judgment. The theory being that by the service of the attachment a lien was acquired upon the bond and mortgage, which could be enforced after judgment, into which the fraudulent assignment was no impediment. The Court of Appeals held, however, that an equitable action could not be brought in such a case until the remedy at law was first exhausted, that is, until the execution on the judgment had been returned unsatisfied, that no lien could be acquired by the attachment upon a bond and mortgage, the legal title to which was in a third person, that in the case of choses in action and debts, the lien is constructive and cannot operate through an intermediate or inchoate legal title, that in such a case no debt at law is owing to the defendant, and there is nothing for the attachment to operate upon, since it can only act upon legal rights, and not upon mere equitable interests. That debts and choses in action are legal assets under the attachment law only when the process acts directly upon the legal title, and that when they are so situated as to require the exercise of the equitable powers of the court to place them in that condition they are to be regarded as equitable assets only, and that, in such a case, to allow the equitable action upon the issuance of an execution, and before its return, would be in direct conflict with the rule that a creditor has no standing in court to reach equitable assets until his remedy at law is exhausted. The decision of the Commission of Appeals, it may be observed, was unanimous, while that of the Court of Appeals was rendered by a majority of the court, 3 judges dissenting, and 3 concurring with the Chief Justice. The Commission of Appeals was a temporary court called into existence to relieve the overcrowded calendar of the Court of Appeals. Its duration as a court was limited, and it has ceased to exist. The Court of Appeals being the permanent appellate court, its decision has been generally followed, though it must be conceded that the relief which the Commission of Appeals attempted to extend would, in many instances, prove highly serviceable to creditors. The decision of the New York Court of Appeals in Thurber v. Blank is not to be taken as being in conflict with the class of cases in which it has been held that an equitable action may be brought after the issuance of an execution, and before its return unsatisfied, to set aside a fraudulent transfer of goods and chattels, or of real estate which can be levied upon under the execution when the fraudulent impediment is removed. SS 87. Distinction between realty and personalty as to issuance of execution. The predicate of the jurisdiction as affecting realty is that the creditor has a lien, and of course if the lien has expired the creditor's action will fail. A judgment is usually a lien upon real property by statute, and hence authority can be found for the proposition that a covenant's conveyance of real property can be attacked by a judgment creditor without the issuance, levy, or return of an execution. Jurisdiction is invoked in such cases in aid of the remedy at law. It may be observed that, as a creditor must usually exhaust the personal property of the judgment debtor before having recourse to the realty, it is generally essential to show, in proceedings to reach the latter, that an execution has been issued. There is, however, an absence of harmony in the authorities. The question recently came before the New York Court of Appeals, and the result of the decision is briefly to the effect that, in an action to set aside a fraudulent conveyance of realty, the complaint must allege the issuance of an execution and its return unsatisfied, or the action must be brought in aid of an execution then outstanding. The authorities in that state, on the general proposition that all available legal remedies must be pursued before resort to equity, are reviewed in Shaw v. Dwight distinguished. This decision being the most recent utterance of the court of last resort, it follows that in New York State at least, execution must issue upon a judgment before a creditor's action, or a suit to annul a fraudulent conveyance of realty can be supported. This places real property and equitable interests on substantially the same basis as regards the status of an attacking creditor, and in some measure restricts his rights to obtain an equitable lien upon property not the subject of levy and sale under execution. The creditor must, of course, have exhausted his remedy under his judgment or decree by the return of an execution unsatisfied. The return of the execution, even as to personally capable of being subjected to a lien, is not always essential. In Buswell v. Links, Chief Justice Dolly said, the equitable aid of the court to set aside a fraudulent conveyance is given where the one invoking it has a lien upon the property which is obstructed by the conveyance. In the case of personal property, a judgment creditor acquires, by the issuing of an execution, a lien upon the personal property of the debtor as against a fraudulent conveyance, and the aid of the court is given in that case to remove the obstruction in the way of the execution, which cannot be done if the execution has been returned, for the lien under it is then at an end. SS 88. Raising the Objection. The objection that the creditor's remedy is at law, or that his bill is without equity, or his lien is suspended, may be raised at the hearing, though it is, of course, safer to bring it up by demurrer, if apparent on the face of the pleading, or by answer, if the defect is not so shown. The court may itself raise the objection. In concluding this chapter, we may state that, as a general rule, under both the old chancery system and the reformed procedure in New York, the bill should generally show affirmatively that an honest attempt has been made to collect the debt by the issuing of an execution against the debtor, and its return unsatisfied, and, where there are several defendants jointly liable, that such effort has been made and the remedy exhausted against all the judgment debtors before jurisdiction will be entertained in chancery. Where the sole purpose of the bill is to subject real property fraudulently alien to the lien of a judgment, the exaction that execution should have been returned is not uniformly enforced.